Say hello and welcome to Resistance Radio. I am John Kane. I am your host, and it is a pleasure, as always, to be a part of your life. However significant or insignificant that may be, I do appreciate being on the air on WBAI in New York City and on WPFW in Washington D.C. And if you listen on either one of those stations, or frankly, if you listen anywhere, I hope that you'll support the two stations that enable me to do a radio show. I mean, yeah, we could do podcasts, but this is radio, and there's a reason for having access, or why having access to areas like the radio market of New York City or the radio market of DC is important to me. Look, we're speaking truth to power. That's what we do. That's, I know that's a common expression, but I also know that much of what I say is not the common narrative. It's not the overwhelming conventional narrative that you're hearing everywhere else. And I don't think anything I say is unreasonable. I think what I say makes sense. I try to offer opinions that are fact based. I try to issue facts along with those opinions. And whether I'm doing it here on this radio program, or whether I do it on my podcast or my YouTube videos, or in my new movie, The Long Hope. And I want to talk a little bit about that, but I also want to talk about why I did the movie. What's the point, and what are we really trying to accomplish? So before I get too started too much, let me just say I do hope that you'll support WBAI and WPFW. You can do so by going to their websites, or by going to their phone lines. And the website for WBAI is Buddy, that's BUDDY .WBAI.org. You can make a one-time donation. You can become a buddy by being a sustaining member of the station. And you can do anything from 5, 10, 15, $20 a month, whatever suits your budget. And and that becomes something that we count on each month. So you can do that. You'll be asked to either do it through your credit card or debit card or your checking account. And it's a safe and secure way to do something on a small continuous basis that adds up through the course of the year. So that's what we ask you to do. Of course, you can still do a one-time donation. You can do any size you like, whether it's monthly or whether it's a one-time donation. So I ask that you support WBAI by going to buddy.wbai.org, or you can call 1-833-922-4692. Yeah, if you want to use letters to help you remember, you can call it 1-833-WBAI-NYC. Again, it'll be the same thing. You'll follow the prompts by the operator. Look, if you happen to get an answer machine, just leave your name and your number, and somebody will get back to you immediately. Sometimes we get multiple calls in at the same time, and so we have to get back to the caller. So if you're listening in Washington D.C., I ask that you go to their website, which is WPFWFM.org, or you can go to their line, their phone numbers, which are 202-588-9739, or they have an 800 number, which is 1-800-222-9739. And again, either way, whether you go to the websites, or whether you make the phone call, you can make a one-time donation. With WPFW, they don't call it the Buddy Program, but it is about enrolling as a sustaining member of the station, and we do encourage you to do that. Again, it makes it easier for us to budget, and hopefully it makes it easier for you to budget, because you're not looking for some large one-time donation. You may be doing something like $10 a month, which for us, that's $120 a year, and that is boy, if we could get that from every one of the listeners that listen to these stations, we wouldn't be begging for money all the time. So there you go. I ask that you support these stations. And look, if you listen to this show as a podcast, which I put it up as a podcast, or if you catch the show as a YouTube video or a Facebook video, you may not feel as compelled to support the radio stations because you're not using the radio stations to hear the program. But I still encourage you to. And make your choice. Look, you can be in Washington and contribute to New York. You can be in New York and contribute to Washington. This is what I'm asking you to do. It's important. We are in an increased time with so much censorship that's happening, not just because of the current administration. Look, dollars alone can be a censor, and this is one of the things that we struggle with. So I ask that you support these radio stations. Show them that your gratitude for providing not just diverse program, but diverse program that includes Me. Includes Resistance Radio. All right. So my buddy Reggie Johnson uh, took my invitation seriously enough to show up at the screening of my film this past weekend at the New School. And so without any coaching, and with probably just a little bit of, leaning on him. I want to get Reggie's thoughts on the film. Because here, look, one thing I will say, it's a long film. It's almost 2 hours long. In the overall scheme of things, with 3 hour, movies that are out there, it's not the longest, but it's long for a documentary. Many documentaries end up being about 90 minutes long, and that's a full length documentary. We're over that, and but we had a lot to say, and we jammed a lot in that 1 hour and 54 minutes. I mean, we jammed a lot in there, and I know there was a lot to take away from it, and watching it one time may have left you a little overwhelmed. We've talked about legal terms. We talked about dollars and cents. We talked about any number of things. We threw a lot of numbers, a lot of dates, a lot of things out there. You don't have to remember any of those things in their totality. You just have to know that these things exist. And so I'm going to talk a little bit about some of what that film was about. But Reggie, what was your thoughts on coming to see the screening?
Well, I thought the screening was very. I really appreciate the documentary, and it had me thinking a lot about what is perceived as what is considered native or not, and down to the people who attended the documentary as well too, because I remember that there was in the front row there was a distinct individuals that came from Central America as well
And South
too,
America, yeah, both, yeah.
and South America, and it had me thinking. It's like for the longest, I have been for the propagandized into thinking that anyone that is outside the imaginary borders of this country, somehow is foreign to his land, and I'm like saying. And I'm glad that I saw what I saw. I saw people there that was obviously native to this land, and it was insulting and just downright offensive to think that how is these people who was watching this film, albeit they understood it in a different language because I know there was an interpreter that was there. How could they not be indigenous or native to this land? And it really just got me thinking about that and the whole premise of what is considered native and to the aspects of treaties that were given, and that was of course they were broken all the time, because that seems like that's the most consistent thing that happens. Promises that are kept broken consistently. And I also found interesting about how really the colonialism of individuals that for whatever reason still needs to be accepted to the status quo, and this being the colonialist white supremacist mindset that even happens to non-white people. And then, we have spoken about that before on this show and in private, is that it is interesting that not only that you have to fight the colonialism from the colonizers, but you have to fight the colonialism within your own people sometimes.
All skin folk ain't kinfolk, as they say.
So true. So true.
No,
But
and
I really appreciate watching it.
well, and that's just it. I mean, and when you consider who is targeted on this immigration enforcement, it's always the people who are the most indigenous that are targeted. I mean, you're not exactly grabbing up Swedish blonde models who might be here illegal. I mean, they even welcomed as refugees the white folks from South Africa who are now claiming to have been persecuted by black people, if you can imagine
Right.
that. So I mean, it's incredible when you consider that the people who lived in this continent, we did have certain migratory patterns. Not everybody was completely nomadic, but not everybody was completely
Right.
stationary either. So when we think about these, when we say these people cross the border, no, the border crossed them. And that's, and we experience it from a Haudenosaunee standpoint as a Mohawk or Gunyagahaga. I mean, there's a border that runs right between our Mohawk communities, between my native communities. I'm hesitant to cross over that white man's line drawn just north of us because of because of the legal implications and that kind of stuff. So yeah, you can't get away from that. But again, to the point of the film, I try to say that the part of the main thrust of the film is to point out what I call illegal doctrines, what the U.S. courts
Right.
and others
Right.
call legal doctrines.
Right.
Now, if you don't know what a legal doctrine is, a legal doctrine is not a law. A legal doctrine is what courts establish as a rationale for making a ruling, and then out of that rationale becomes what they call a legal doctrine that other laws can be built upon. And there's three legal doctrines that I talked about in great deal on this program all the time. Obviously, the doctrine of Christian discovery is one that I talk about a lot, going back to my earliest days with Stephen Newcomb on my program and the like. But out of that doctrine of Christian discovery, which is about this notion that a Christian peoples, European Christians, could once they laid their eyes on land that was occupied by non-Christians, they could claim not only the land, but they could claim the people. And that's what the doctrine of Christian discovery is essentially is. I mean, some try to turn it into, well, it's about discovery title. And so they take the word Christian right out of it. But this was born out of the papal bulls of Rome. That's where this comes from. Before there was even any kind of separation of Protestant and various denominations of Christianity, there was just one church, and the Pope, the leader of that church, or a series of those popes, made these decrees, these papal bulls that established this notion that a Christian nation could claim the land title and the possessions and the freedom of the people on lands occupied by pagans. And that's what the doctrine of Christian discovery is. Out of that, was born two other legal doctrines. One is called the trust doctrine, which is where, in spite of the fact that we weren't even a part of the United States, even though we were sharing some of the same lands, we weren't included in the U.S. Constitution at all, not at all, not even 3/5 of a person. We weren't even that. We were just excluded, which was fine by us because we didn't want any part of that. But then, lo and behold, the United States decides, well, we're going to call you wards of the government. We're not even their citizens. We're not their property. We're nothing like that. And yet they declare that we are wards of the federal government. And then out of that becomes them appointing themselves as our trustees. Now, there's no legally binding trust. There's no trust document. There's none of the attributes of a legally binding trust. But this is what the United States has spoon-fed us. And frankly, some Native people have embraced it. So that's one of the other legal doctrines, the trust doctrine. And then the final and most extreme is the plenary powers doctrine. And for those who don't recall what plenary means, it means ultimate. So when we say ultimate power, we mean ultimate authority. And what the plenary powers doctrine says is that Congress has that over Native people, not over everything else. I mean, Congress is not an unequal branch of the federal government in any other regard. But when it comes to Native people, Congress has been designated by the courts, these activist judges, you know those guys, right? These courts, they have been designated as having ultimate and exclusive power over Native people. And when I say exclusive, it's both exclusive in its exercise over us, it's exclusively including us, and it's exclusive to Congress. And honestly, it can't even be challenged. And I'm going to talk about that a little bit. So these three legal doctrines, and that's what I try to expose in the film. I try to show how they defy morality. They really defy law. They certainly defy the U.S. Constitution. And I'm not alone in this view. There's a couple of guys with big black robes who sit on the Supreme Court who agree with me. You might be surprised who they are and who they aren't. But I'm going to talk about that today. That's what I wanted to talk about today. Because we have to end this. Our final message in the film is that we need to wipe these three legal doctrines off the record and off the lips of people who speak them. That's what we need to do. So yeah, Native people face a lot of challenges, but most of the challenges has to do with authoritarian rule over our lands, our resources, and our people. And it all comes to the hands of these three legal doctrines. So here's the thing. When you hear stuff like this, the assumption you got to that you must make because of the polarization that exists in the United States was, oh, that must be just the extreme right that does that. Yeah, that's got to be this extreme court, this 9-3 or the 6-3 Supreme Court. No, no, it has been regarded as settled law for over 100 years, for actually close to 200 years. I mean, these legal doctrines are slave era, pre-Civil War, 1820s, that would be 200 years ago, to the 1830s, almost 200 years ago. That's how old. And think about the reasoning and the sensibilities that went into a law from over 200 years ago. This, again, keep in mind, slavery wasn't just legal; it was one of the biggest businesses. The chattel slavery industry represented in the United States the number one most valued assets of industry. And most of that industry was agriculture, but still, the most valued assets of industry in the United States in this time period is the idea of enslaving people. So where does this idea of enslavement come from anyway? Well, didn't slaves exist in other parts of the world? Yeah, but not chattel slavery. Not this kind of slavery where not only can you buy and sell people on on an ongoing basis, but their children are slaves, and there's no getting out of it. That's the difference between the chattel slavery industry in the United States, which started with colonization, but really expanded once they fought for liberty and freedom, is when slavery became like the number one part of the United States subculture. So where does it come from? Well, remember those papal bulls I talked about? Doctrine of Christian Discovery? It's the church that didn't just authorize, but they promoted the idea of enslaving non-Christians. And of course, they also promoted the idea of converting them and turning them into Christians, but it doesn't mean they get released from slavery. No, that doesn't mean that. And here's the crazy part. There was actually a papal bull that came out after the first 3 or 4 that really established the doctrine of Christian discovery, which said it wasn't right for indigenous people to be enslaved. But when the church made that decree, nobody released any slaves. This is still in I think the late 1500s that this fourth papal bull came out. So that got ignored. And see, that's the thing. When we look at things in history, there are certain things that on the face of it, well, that sounds really good. That sounds right. Justice for all, liberty and justice for all, the right to pursue happiness and all that freedom, all that stuff. Then there's the other stuff, the stuff that stops all that. There's all of these things that happen, and you got to think about, okay, but what persevered? I mean, in the 1790s, the United States entered into treaties, and those treaties would exist for another 100 years. There would be treaty making. But in the 1790s, the United States recognized fully in their language. They wrote these things. We never. Let me just say this: Native people never asked for a treaty. We never did. We never asked for a surrender agreement. We never asked for any kind of treaty. We were always pursued with these treaties. And it's not, as you mentioned, Reggie, that treaties were just broken. I don't think they were ever intended to be followed. I think it was lip service. They were lying to us even as they entered into them. That's what they did. And I
agree.
And the proof of it is the fact that they didn't. You could tell they never intended to honor any of them. I mean, any of them. So, but in these treaties, this is an example. The Canandaigua Treaty, and I'm not a fan of any of these treaties because most of them involve us losing something, not gaining something. But in the Canandaigua Treaty, it says 3 times that the United States recognizes that we own the land, and it was referring to various nations, but and it's really spelled out clearly with the Senecas that the United States recognized that the land belonged to the Senecas, and the United States will never claim the same, nor will they interfere or in any way impede the free use and enjoyment of that land by the Senecas, by the friends and allies living amongst them. So it says they recognize that the land is ours. There was no question about title. The United States acknowledged it, and we're not the only ones they did this with. They did this. There may literally be dozens, if not 50 or more treaties where the United States recognized land ownership. Now that's in the 1790s. But in 1823, the longest serving Chief Justice of the Supreme Court, a guy by the name of John Marshall, he brings this idea of these papal bulls and this doctrine of Christian discovery and embeds it into U.S. law. And it was in a case that really wasn't between native peoples. There's a case called Johnson v. McIntosh, and these are two white guys fighting over land. And the one white guy says, well, I got the land from the native people, and the other guy says, well, I got it from the federal government. So because there was this question about how land use was transferred, because it was actually leased, it wasn't even title. But as this was being debated in the courts, this was an opportunity for John Marshall to solve a huge problem for the United States, which was, how do we claim the land as even ours? And so this is where the doctrine of Christian discovery in 1823 becomes codified in U.S. law. And he doesn't just claim that the discovery of these lands entitled them to take title. He does that, but he doesn't just stop there. He actually talks about what he calls an extravagant pretension, which was this idea of converting the discovery of an occupied country, he called it. He didn't even call it land. He called it a country, an occupied country, of converting that discovery of a land that's already got people on it into conquest of that land and those people. He says, if we can pull this off, if we can do this, if we can do it in the first instance and then sustain it, and then build upon it, build communities and build, colonies and, cities and all this stuff, then it can't be challenged. Then it becomes the law of the land. That's what John Marshall said. He said, if you tell a lie enough, and if you stand on that lie and build upon that lie, the lie becomes truth. That's literally what the longest serving Supreme Court justice of the Supreme Court said. By all means, look it up. If you just Google search John Marshall's extravagant pretension, you'll get it. So you don't even have to go looking hard. I try to make this stuff easy to find, because look, I'm saying stuff that seems unreasonable. Because when I say this, and I say, and this is a part of U.S. law, you got to think, no way that could be part of U.S. law. But I encourage you to look it up. So, the crazy part is, he says, if you can assert it in the first instance, you didn't assert it in the first instance. In the first instance, you recognized that we had title land in all those treaties. But all those treaties fell victim to John Marshall codifying the doctrine of discovery. And there would be more treaties after that. You would think that once he said this stuff, treaties must have come to an end then, because the native people don't even own the land. What he said is, we only had the right of occupancy. Well, what does that even mean? Well, it turns out a much later court in the 1950s, the same court who decided that segregation was racist and illegal and unconstitutional, that same court, the same men on that court, of course they were men, ruled in a case involving the Tlingit, in a case called Tehitan versus the United States. They said, because the Tehitan were basically saying, look, you took all our trees. You literally stole the lumber. You took the timber. We're entitled to compensation. And the court said, no, you're not really entitled to it, because the right of occupancy doesn't necessarily mean that you own the land or you own the resources. And Congress can eliminate that right and any recourse you might have to resources on that with the swipe of a pen. You're not entitled to compensation. You're not entitled to long-term occupancy, because we can remove you from the land, we can take your resources, and you're not due any compensation. So the same guys who could recognize racism when it came to education and of black children had no problem just signing the papers to steal resources from Native people. That's, I oftentimes talk about the unique racism that Native people experience, and it's not to diminish the racism that other people experience, especially black people in the United States. But the fact is that there's distinction. I talk about this in the mascot issue. You don't see any school using a black mascot. You don't see a bunch of white kids going to their pep rallies in blackface. You just don't see it. But you see them in red face. You see them with feathers on their head. You see them mocking Native people. So there's all these examples, right? But I'm not done with the legal doctrines. So this one was bad enough, and it turns into this whole premise for the United States to claim underlying legal authority and ultimate title to native lands. That's what they said. That's what they claim. And if you were thinking, but yeah, but didn't that a long time ago? Well, I've mentioned this before. The liberal darling of the Supreme Court, Ruth Bader Ginsburg, she cited this thing in 2005. She literally spelled out the doctrine of discovery in her footnotes. She said basically the title to the land occupied by native people when became vested in the sovereign, first the discovering nations of Europe, then the colonies, then the states, and the United States. Now, she doesn't say how it became vested. She just says it as a matter of fact. And that's what we see in these court cases. We see over and over again judges who will write in their opinions these things that on the face of it say, well, that's not right. Yeah, but they're not saying whether it's right or wrong. They're saying, yeah, but that's the way it's been handed to me from the previous court. And we're just going to state it as a matter of fact. We're going to state these unlawful, unconstitutional ideals as settled law. So that's Ruth Bader Ginsburg. That's just 20 years ago. 20 years ago. But it gets worse. Why? Because 4 weeks ago, another court in California, it was an appeals court, 3-judge panel in California, cited not just Johnson v. McIntosh, but they actually cited the that they claimed that they how do they write it here? I got it in front of me. So they said, asserted title to these lands through discovery. That's what they said. They said they asserted it by discovery. So again, what they're asserting is the doctrine of Christian discovery. And they basically just said, natives just had a right of occupancy. And then they go on to say, and they say more, because they say, in the 19th century, through treaties, the federal government sought to confine tribes to reservations. Do you think we ever entered into a treaty? And for a treaty to be really a treaty, it should be mutual, right? In what world would Native people say, well, we want to enter into a treaty where you confine us to a reservation? No. Native people were confined to reservations by military, by massacres, by killing members of those people. That's why they were confined. They didn't do it because we want this treaty protection. No, that's not what they asked for. So it wasn't by treaty. It was by aggression that Native people became confined. And there's an expression, Reg, I don't know if you ever heard. You ever hear what somebody say, well, such and such really went off the reservation on that one? Well, off the reservation meant it's a reference to us, because the good Indians were the ones who stayed confined. The evil, bad, and hostiles were the ones who said, oh, hell no, I'm not staying here. This is all my land. I'm going to all of it. So the idea of referring to somebody as having gone off the reservation meant that they were wild, they were untamed, and frankly, once a Native person left the reservation, they could be killed as a hostile. They could be designated an enemy combatant just for not staying within essentially these prison camps. But so this 3-judge panel, and it's 3 of them, and they all concurred on this notion. One guy wrote it, but they all agreed with it. And they go on to say that Congress passed the General Allotment Act in 1887, also known as the Dawes Act, which sought to extinguish tribal sovereignty. I mean, they say it. They don't just kind of say, well, that was an unfortunate happenstance of passing that. No, they say that was the intent. So we always talk about intent, right, with the law. If you kill somebody, but it was by accident, well, that might be manslaughter, or if it was incidental. But if you do it on purpose, it's murder. Well, it's the same thing with genocide. Genocide is laced with this idea that in order for the 5 attributes that are designated or recognized as the overt acts that constitute genocide, there still has to be intent. It's not that you just got to kill people. It's not that you just torture or injure people or rape them but if you do it with the intent to destroy them, see, that's how it becomes genocide. So they write this, and they keep going. I mean, one goal of the allotment policy was to assimilate Indians into Anglo-American culture. Another was to open lands to white settlement. So these 3 judges are writing this stuff fully acknowledging that all of their policies in this time frame and before were geared towards screwing us. I mean, and there's no, you can't, I mean, you can't massage these things, but because they say it just as a matter of fact, they just kind of keep going with it. They never challenge this. So these three judges never challenged the principle of the doctrine of discovery. And the crazy part is, in case you're wondering what the case was about, but the case is called Halverson versus Burgum. Burgum is the Interior Secretary. Yeah, you know, the one that job that Deb Haaland, the Indian princess, used to have. Well, now it's a rich white guy who's got it. And so he becomes the defendant in this case. And what this Halverson was trying to do was trying to sue the federal government, sue the Interior Department, Burgum, into doing his job. What an idea. So he's trying to sue him into doing his job. And what was the job that he was trying to sue him to do? Was to sort out disputed land issues that was caused by the very Allotment Act that these guys are talking about. And so the court originally, which got handed down to this three-judge panel, said, well, you can't sue him because of sovereign immunity. Now, if you watch my film, The Long Hope, there's a section in there where myself and Ross John are talking about going to Washington, D.C., because the Obama administration wanted to revisit the UN Declaration on the Rights of Indigenous Peoples. And while we were sitting there in an opportunity to exchange with all of these the leaders of all these federal agencies, they kept referring to the concern that the United States had about this new UN declaration, this new international policy, that it would interfere with the current remedy for conflict resolution between the United States and Native people. And they kept saying this, the current remedy, current remedy, current remedy. So finally I raised my hand and said, so what is this current remedy? And they said, oh, our court system. Oh, so you mean the court system that developed these illegal, unlawful, immoral, unethical legal doctrines? That's the remedy? Or the same courts that say, oh, no, you can't sue us because we have sovereign immunity? I mean, you can't make this stuff up, folks. You just can't make this stuff up. So that's kind of where the doctrine of discovery, lies. And so if you think that, well, this was just about all the land we lost, no, it's still being used in courts. A month ago, 4 weeks ago, it was cited in this opinion, in this ruling. Not just an opinion, a ruling. This is the concurrent opinion. This is the affirming ruling, and there's no dissenting opinion because it was a 3-judge panel and they were unanimous. So what this brings me back to is, when do any of these judges, and they call themselves justices? I mean, how ironic is it that they actually use the word justice as part of their title? Supreme Court justices. Well, where's the justice? So you got to ask, doesn't anybody see that there's problems with this notion of doctrine of discovery, the trust doctrine, or the plenary powers doctrine? Well, yeah, some of them do. Oh, so I know what you're saying is, it must be that Ketanji Jackson or that Elena Kagan or that Sonia Sotomayor. No, it's not. It's two of the justices that, by all accounts, the liberals hate. And I'm not a big fan of these guys either, to be honest with you. Clarence Thomas and Sam Alito are the only two justices that have gone on record in written opinions that they wrote or in oral arguments that they made that question the plenary powers doctrine. So they question the plenary powers doctrine. And frankly, Alito questioned the trust doctrine as well. Let me read a little bit from good old Sam Alito. So there was a case called U.S. versus Jicarilla Apache Nation. And this was the Apache that were trying to sue for the contract negotiations. They wanted to know, how is it the United States, who was serving as their trustee, was negotiating mining contracts on their land, and they couldn't get access to any of the negotiations. So they sued for it. And the United States says, nah, you can't really have that information because that's lawyer-client privilege. And so the Apache said, yeah, but we're the client. The United States is merely serving as our trustee. And they said, no, that's not really the way it works. He goes, you don't really have a trust. And this is literally what Sam Alito has said. He said, as we have recognized in prior cases, Congress may style its relations, with the Indians a trust without assuming all, or in many, in this case, any of the fiduciary responsibilities of a private trust, creating a trust relationship that is limited or bare compared to a trust relationship between private parties at common law. So in other words, this doesn't even fit within the legal definition of a trust. And Alito is saying it. But he goes on, he goes, throughout the history of the Indian trust relationship, we have recognized the organization and management of the trust is a sovereign function subject to the plenary powers of Congress. So now he's kind of even putting the, like in circular reasoning, saying, well, the trust that we talk about is really just a function of us having ultimate power over Native people. That's what he says. He says, because the Indian trust relationship represents an exercise of that authority, meaning Congress's, we have explained that the government has a real and direct interest in the guardianship it exercises over the Indian tribes. And interest is one in which is vested in it as a sovereign. So notice I say guardianship, not to protect Native people, but guardianship over. See, there's a lot of word replacement stuff here. So when they say guardianship, they just mean control, that it's all about control. Again, this is Sam Alito, the conservative justice. He says, this is especially so because the government has often structured the trust relationship to pursue its own policy goals. See, let me say it again. They structure this to pursue the government's goals, not to serve a beneficiary of the trust who they've regarded as wards of the federal government. I mean, we're considered the incompetents, and yet they're the ones who are breaking their own laws to assert power over us. I mean, that's pretty remarkable by itself. Thus, while trust administration relates to the welfare of the Indians, the maintenance and the limitations which Congress has prescribed as a part of its plan of distribution is distinctly in the interest of the United States. I mean, look, you can't say it any more clearly that the whole trust doctrine is BS. It's just not true. This is what I talk about in my film, by the way. So how is it that Sam Alito writes this and Kagan, Sotomayor, and Jackson just look the other way? They ignore the fact that what he's saying here is really principled law. That this whole trust relationship stuff is based upon is that it's false. So my question is, how is it that the guy that is supposed to be, the arch enemy of freedom and justice, right, really, is the only one saying the truth here? He's the only one saying the truth here. Where are those three liberal justices? We already know where Ruth Bader Ginsburg was. She was throwing us under the bus under the doctrine of Christian discovery. But these three, Kagan, Sotomayor, and Jackson, I mean, I got to assume we all expect more out of them, don't we? I mean, don't we? Because they keep establishing this stuff as settled law. And again, that's just the trust doctrine. What about that plenary powers thing? There's two justices that have raised issues about the plenary powers, and one of them is Clarence Thomas, of all people, one of the most right-wing and probably corrupt judges on the Supreme Court, justices on the Supreme Court. I got to keep calling them justices because it's kind of funny. In 2004, around the same time that Ginsburg is writing the opinion for an 8-1 majority ruling against the Oneidas acquiring lost lands, citing the doctrine of Christian discovery in the process, in 2004, a year before that, there was a case involving kind of a bad character, a Native guy who was an abuser. He was guilty of domestic violence against his partner. He was actually told he couldn't live there. He was from another nation. So this guy's name was Billy Joe Lara. He was told by the courts of the woman who he was abusing. They said, no, you're not welcome here. You're banned from this territory. Well, he showed up anyway. And when the tribal police showed up, he punched one of them. So he was arrested on the spot. He was charged with assaulting a tribal officer. But then what happened was the federal court said, one of those guys that he assaulted was a BIA. He came from the Office of Tribal Justice at the federal government. So we're going to charge him with assaulting a federal officer as well. So he served his 90 days for assaulting the tribal officer, but now he was facing a more serious offense because he assaulted a federal officer. Now, we can all have different opinions about all that, but so what came out of this thing was this battle where Lara was saying, well, you can't charge me. That's double jeopardy. You can't charge me at the federal level for something I've already addressed at the local level. And the federal government, so here's a strange case, because you got the federal government taking the view that the authority of the tribal police and the tribal courts doesn't come from the federal government, that it comes from inherent sovereignty. So the fact is that the federal government can charge them because they are not connected. The two jurisdictions are not connected. One comes from the inherent sovereignty of Native people, and the other one, comes from the federal government. And so Billy Joe Lara is saying, wait a minute, you guys control our courts. And the federal government saying, nope. So Billy Joe Lara ends up getting charged and it goes all the way to the Supreme Court. And the Supreme Court rules that, yes, he can be charged at the federal level after already having been charged at the tribal level. One judge who concurred with that opinion wrote something different, though, and that was Clarence Thomas. Clarence Thomas had problems with some of the argument that the rest of the court was using, which was plenary powers. He flat out said in a concurrent but separate opinion, and you can look it up. Look up the Clarence Thomas opinion in U.S. v. Lara, Lara. And he says, I don't see where there's any constitutional basis for the plenary powers. It's not in there. It's not in the treaty clause. It's not in the Commerce Clause. All the places that that this thing was claimed to have been existed way back from Chief Justice John Marshall, who claimed that the framers of the Constitution intended Congress to have that power. And Clarence Thomas saying, I don't see it. So that was him in 2004. Well, just a few years ago, when a white family was trying to adopt a Native child, a family called the Brackeens, they challenged the Indian Child Welfare Act. And the Indian Child Welfare Act came, I think, in 1978, somewhere along those lines, and it was intended to put a nail in the coffin, I guess, of residential schools and put an end to what was considered the part of the 60s scoop, this idea that Native kids were being swooped up and put into foster care and adopted out to white people. I mean, and this was this was almost an enterprise, because for all intents and purposes, the kids were being sold to white people. So the Brackeens wanted to adopt this child, and they wanted to challenge the Indian Child Welfare Act. Now, the Indian Child Welfare Act doesn't ever say Native people get to decide where Native kids go. It never says that. What it says is the federal government was going to put up guardrails to the state child protective services and direct them that they had to prioritize placing a Native child in a Native household. They said they didn't even care if it was the same nation or the same, I hate to use the word tribe. They said it's just that important for the perpetuation of Native culture that a child be raised by Native people. So the Brackeens are saying, well, how is that constitutional? I mean, if we're all Americans, and of course, you know my feeling on that, how can white people, because of their race, be denied the opportunity to adopt a Native child? That's a violation of the 14th Amendment, the Equal Protection Clause. They said it's also a violation of states' rights because the federal government is telling the state how they have to administer this power that had been almost exclusively exercised by states. And their challenge failed. And it failed on one argument: plenary powers. The court said, well, Congress passed that law. and Congress can do whatever it wants. That's what the court said. 2 justices voted against that or deferred from that opinion. Again, Clarence Thomas and Sam Alito. Because Sam Alito asked the question, he said, wait a second here. And during the oral arguments, he was asking the Solicitor General, who was representing the United States, he said, so if plenary means plenary, then it seems like the United States can do whatever it wants to Native people. And the Solicitor General, a guy by, I think his name was Edward Needler, said, yeah, that's correct. So if there are any limits to that power, he goes, I don't see where any of those limits are. So Needler says, well, they still got to remain consistent with their trust responsibility. But the trust responsibility was an exercise of the plenary power. So how could that be the checks and balances here? So Sam Alito recognized that this plenary powers is an unlimited power that is founded in no place. And in fact, when wealthy, rich people with oil money tried to challenge this, and he says, no, you can't challenge this. Because we, the courts, have already established that it's settled law that Congress can do whatever it wants to Native people. Only Native people. And it can't be challenged for its constitutionality. It can't be challenged because of equal protection clause. It can't be challenged because of abusing states' rights. Because when Congress passes a law regarding Native people, it's unchallengeable. That's what the standard court response has been. But 2 justices, right-wing justices, are saying, we don't agree with that. And I mean, I don't know that they were trying to get this little girl adopted by this rich white family, but they said, we can't concur because we have an issue with this, with defending this law only through the plenary powers doctrine. We have a problem with that. You know which 3 of the judges who voted to assert this plenary powers? Kagan, Sotomayor, and Jackson. So, look, if you're going to school and you're studying law, or if you write any legal reviews of any kind, my question is to those 3, when are you going to read the law? When are you going to read the fact that the UN Declaration on the Rights of Indigenous Peoples condemns those 3 policies almost specifically? What do they say? I'll read it for you. This is what the UN Declaration on the Rights of Indigenous Peoples says. It's in their preamble. And it says, affirming further that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Well, if you created a specific series of legal doctrines that are based solely on authoritarian rule or some sort of Christian dogma, then you are inconsistent with what the rest of the United Nations has said. Now, I don't see a whole lot of nations rushing to our defense here, just like I don't see 3 of those Supreme Court justices rushing to our defense. But if there's one thing that I'm trying to do with our film, The Long Hope, it's to expose this. And I'm hoping if this show broadcasts in Washington, D.C., I hope somebody will poke a couple of these liberal justices, because we already got a couple. We've already got 2 of the conservative justices. We have the majority of the court if those 3 liberal justices would shake it off. If they would do what's right, what's moral, ethical, legally valid, and condemn and do as we ask in the film, eliminate these legal doctrines. Eliminate them from your law, eliminate them from your policies, and wipe them from your lips. We don't ever want to hear about the doctrine of Christian discovery again, or Johnson v. McIntosh. We don't want to hear about the trust responsibility. I don't want to hear, and I sure don't want to hear from my own people. We don't want to hear people say, oh, the United States has a trust responsibility. No, they don't. They have debt and obligation. And they probably owe us some money for reparations for things like, I don't know, murdering tens of thousands of kids, raping tens of thousands of kids in the residential schools, committing genocide. Yeah, there's probably some compensation that needs to come to them. Look, if a little white boy grows into a man and they can sue the Catholic Church and get $10 million from the Catholic Church for having been molested, then what about us? Thousands of kids were raped. Babies were actually thrown into incinerators to cover up the crime of rape. I'm going to screen Sugarcane out in Hofstra the day after Indigenous Peoples Day on October 14th. I hope some of you will come out. I'm going to do a Q&A there. We're going to continue to screen our film, The Long Hope, in New York City and in Washington and in a bunch of native territories. I hope if you get the opportunity, and eventually we will put this on a streaming service, whether we do it directly onto YouTube or Vimeo, or whether we get a streaming service to pick us up. We are at a couple of film festivals. We're hoping that we get enough attention. I know we aren't telling a romantic story. We aren't telling a story that makes people comfortable. I'm sure, Reggie, you did not leave that room feeling better about yourself after watching that film. And if you did,
Nope.
and if you did, we need to have a discussion. No, because it is a terrible story. Everything I just told you here in this hour is a terrible story, but it's all true. I ask you to look it up. Just search Sam Alito on the trust responsibility. Search the Hickory Apache case. Search the U.S. versus Lara. I mean, I'm doing the hard work so I can present it to you guys so you have it more easily and more available to you. That's what I'm doing. I'm trying to make this information available. I didn't write it. I didn't invent it. I did a movie on it. And I'm hoping that you'll get a chance to see the film. But in the meantime, look, if you're studying law or if you're studying anything associated with public policy, and if you have the opportunity to raise this issue, because look, I'm trying to use this film to educate my people, but I also need allyship. We have no power over the Supreme Court. You might feel like you have no power over the Supreme Court, but you know what? You do. You really do. You can influence things. And I got to think that those three justices, those three lady justices, Sotomayor, Kagan, and Jackson, if somebody ever had a conversation, I mean, even Ruth Bader Ginsburg regretted her ruling in the city of Sherrill versus the United Nations. She wrote about it in her book. It didn't change anything. Might have sold her a few more books. I don't know. But I got to think if somehow these justices, and maybe even a couple more of the conservative justices, I mean, we got Clarence Thomas and Sam Alito questioning the power of the United States, which they never do. They seem to bolster all of it. Of course, you got to remember, plenary powers isn't about giving the president power, which is what these guys seem hell-bent on doing. It's about the power of Congress. But these two are at least questioning that. So look, I'm glad you listened to this program. It's the first time I presented this it quite this way. I talked about stuff I've talked about before, and I'm going to revisit this time and time again. So, hey, let's pester those three justices and see if we can't get them to see the light, so to speak. I want to thank you for listening. I'm John Kane, and this is Resistance Radio. Yahweh.